Many foreign investors and companies operating in Vietnam rely on non-compete agreements to protect their business. On paper, these clauses appear clear and enforceable. They restrict employees or partners from competing after leaving the company. But in reality, enforcing non-compete agreements in Vietnam is far more complex, because the true test of any non-compete clause is not how it is written, but whether it can be enforced in practice. Under Vietnamese law, non-compete agreements are not explicitly regulated in a comprehensive way. Instead, they are interpreted through a combination of labor law principles and civil law concepts. This creates a legal environment where enforceability depends heavily on context. Vietnamese courts tend to prioritize the employee's right to work. As a result, any restriction on future employment must be carefully justified. The central issue in enforcing non-compete agreements in Vietnam is balance. On one side, employers want to protect trade secrets, client relationships, and proprietary know-how. On the other side, employees have a fundamental right to earn a living. If a non-compete clause is seen as overly restrictive, courts may limit or reject its enforcement. This makes drafting strategy critically important. In practice, Vietnamese courts are more receptive to non-compete obligations when certain conditions are met. For example, when the restriction is reasonable in duration and scope, when it applies to specific roles with access to sensitive information, and when the employer can demonstrate a legitimate business interest. Non-compete clauses tied to senior employees or key personnel are generally viewed more favorably. Non-compete agreements in Vietnam are often enforced in connection with confidentiality obligations. This means the stronger your protection of confidential information, the stronger your non-compete position. Courts are more likely to support restrictions that are clearly linked to the protection of trade secrets or sensitive business data. Without this connection, our non-compete clause may appear unjustified. One important factor in practice is compensation. While not always mandatory under Vietnamese law, providing compensation during the non-compete period can strengthen enforceability. It shows that the restriction is not purely one-sided. Instead, it reflects a fair balance between employer protection and employee rights. Many successful enforcement strategies incorporate this element. Even with a well-drafted, non-compete agreement, enforcement depends on evidence. Employers must prove that the former employee is engaging in competitive activities that violate the agreement. This is often difficult, especially when competitive behavior is indirect or not publicly visible. Without clear evidence, enforcement becomes uncertain. In practice, Vietnamese courts may not fully enforce our non-compete clause as written. Instead, they may adjust its scope to make it more reasonable. For example, reducing the duration or narrowing the geographic limitation. This reflects a pragmatic approach. Rather than rejecting the clause entirely, courts reshape it to align with legal principles. Many foreign investors rely on standard templates from other jurisdictions. However, these templates often do not align with Vietnamese legal realities. Some clauses are too broad, others lack a clear link to legitimate business interests. And some fail to consider enforcement mechanisms under local law. These mistakes significantly weaken enforceability. Enforcing non-compete agreements in Vietnam requires more than drafting a contract. It requires a strategic approach. This includes identifying which roles truly require non-compete protection, defining reasonable limitations, and integrating confidentiality measures. It also involves preparing for potential disputes from the outset. A well-structured strategy improves both deterrence and enforceability. For foreign investors, non-compete enforcement is directly linked to business protection. Loss of key employees can lead to loss of clients, market knowledge, and competitive advantage. Without enforceable restrictions, these risks increase significantly. Understanding the challenges and realities of enforcement in Vietnam is essential for protecting long-term value. At LTS Law, we support foreign investors in Vietnam by designing non-compete strategies that are aligned with local legal practice. We go beyond drafting to ensure that agreements are structured for enforceability. This includes legal analysis, risk assessment, and dispute preparedness. Our goal is to turn contractual clauses into real, enforceable protection. A non-compete agreement in Vietnam is not just a legal document, it is a risk management tool. Before relying on it, companies must understand how enforcement works in reality. Visit lts.com.vn to consult with our legal team and ensure your non-compete agreements in Vietnam are built to withstand real-world challenges.